Good morning. I'm attorney Gary Finklea from the Finklea Law Firm in Florence, South Carolina. I would like to speak with you briefly regarding uninsured motorist claims in South Carolina. Generally, there's two occasions where an uninsured motorist claim is made. The first is where the at-fault party has no insurance or is uninsured. And the second one is where there is what we call a John Doe claim. I'll explain both briefly. First, if you're involved in an accident and the at-fault party has no insurance, in that case the at-fault party is uninsured, your insurance company basically steps into the shoes of the at-fault party and investigates, negotiates, and hopefully settles and pays the claim. If, of course, they do not settle, we file suit. But that's the first occasion, is where the other party is uninsured. Your insurance company steps into the shoes of the at-fault party. In those cases, it's important to be aware at the initiation of the claim that although you may be discussing the facts of the accident with your insurance company will actually be adverse to you when it comes time to investigate, negotiate, and settle the claim. So be cautious of the information shared and how you handle yourself in those matters. The second case is what we call a John Doe claim. And a John Doe claim is generally hit-and-run type accidents where the at-fault party hits you or causes you to wreck. In hit-and-run cases, usually there's two types. One where there's physical contact between you and the at-fault party, and the other occasions where there's actually no physical contact, yet the at-fault party causes the accident. For example, they swerve abruptly in front of you, and even though there's no contact, you slam on brakes, swerve to avoid, lose control, and wreck. In those cases, that's a John Doe claim where no physical contact was involved. A lot of people are misinformed as to those types of claims, and many people believe they don't have a claim. That's wrong. You can make a claim under your uninsured motorist coverage provided you meet the statutory elements, and generally there's three of them. First, the accident must be reported within a reasonable time. Second, you must not be at fault for determining the identity of the at-fault party. In other words, if you can, get the license tag number, description of the car, get as much information as you can before they leave the scene. And the third is, if there was physical contact, that's the simplest way to prove the third element, but if there's no physical contact, then you have to have an independent witness to verify that this third party, this John Doe, caused the accident, and that third party must sign an affidavit verifying those facts. So those are generally the two ways in which an uninsured claim can be made. When uninsured claims are made, generally you need a lawyer. They're complicated. You need to be aware of how to handle yourself with the insurance companies. You need to be aware of the coverages available. Also, if your damages exceed your policy limits, you need to be aware as to whether or not you can stack your insurance coverages to gain additional insurance coverage. So if you have any questions concerning any sort of auto claim, whether it's uninsured, underinsured, or just a liability claim, please feel free to contact me at Finklea Law Firm, 843-317-4900, or by email, gfinkley@finklealaw.com, and our website is finklealaw.com. Thank you very much.